Don't put your hands. Stop resisting. You got it. Got it. She had every chance to walk away.
On March 5th, 2022, a woman with a service dog was arrested for battery on a law enforcement officer. After making physical contact with an officer while attempting to explain an earlier altercation, what she likely believed was innocent demonstrative touching constituted a third-degree felony under Florida law, carrying up to 5 years in prison. This case illustrates a critical legal boundary many citizens misunderstand.
Well, we have this.
That's the old lady. I don't know if you think I don't know the law. I wouldn't know because that's the old lady. Now, the old lady came down
It's on video. Let's go. Don't put your hands. Stop resisting. You got it. Got it. She had every chance to walk away. She had absolutely every chance to leave.
No, I'm just coming.
No, the other friend got taken off. Now, she had all chances to leave. The friend tried to talk sense to her.
Excuse me, sir.
You got the handcuff in there.
I haven't even.
Hold on. You can slide it out, slide it out.
Excuse me.
One second. Stop moving.
Sit up. I'm confused. I didn't even touch that man. What are you?
Ready? You're full. 164 Central. You gotta take your dog. We'll get in the cuffs too.
Stuck in there. No. 161 and Sergeant Jones and Sergeant Sleeper are with him. We'll get it.
About your dog.
No, it's not about my dog.
Hang out over there for us, okay? I know. But when you touch me, that's a no-no.
Look all the time, like.
Is that her only one?
What? No, I'm literally not bad.
Stop.
We're gonna take pictures of the injuries.
We're gonna get all the pictures.
That's all I say. Face. Well, we got that one. The face, maybe. Look this way. Look at dirt.
And a
Look
wrist.
that way.
No, like, I'm so sorry.
Hey, it's all good.
No.
Now your identification is set.
And a wrist. She's bleeding right there.
This is the dynamic. Yeah, no, this is.
I don't want to take them off yet until she gets here.
Stop moving around.
I got it.
Got it? up here. It's okay. Did you hit me on the top of my head?
3 Victor, 164
Hey,
Central.
can I show you what you did to me? You didn't do that. You didn't do that. You didn't do that.
Look, Florida DL by number.
Right identified.
All right,
hold on.
do not move.
I don't have anything.
No, we're just taking this off.
Being like I'm a ruin. I don't have any intention of resistance. I didn't even want it to.
All right, hold on.
I got it.
I promise to God, I'm not. Anyway.
Popped me on the top of my head.
I should
Come on. Come on over here. Where is? Hit him though, the officer.
She smacked him on top of the head.
Well, that's hitting him. Okay, you can show him without actually touching him.
I
though.
didn't touch him on
You
the
didn't even tell me ahead of time. Hey, can I show you what you did?
Right. So
I was
cannot
holding the
put
whole.
She's got a
Hey.
she's got a bracelet, just so you know.
Take it.
I have a.
Take it.
We're gonna get the
I'm so confused.
Whenever you're.
Where are the keys?
Yeah, put it on top of the handcuffs so we can get it off.
Just give my whole bunch of my.
Stop moving, please. Thank you.
Bro, what is?
Did she take the whole purse?
Just give it all to her. You're taking for explaining to you what I got arrested for. Something doesn't really have to be that hard.
Hey, they're being uploaded
Come to
now.
me.
Go to man.
Bitch, I ain't got no drugs. What you making me so hard for, bro? No, cause now I'm gonna call the bro. But what you making me so hard for? So that police, what happened?
Hold on.
Top of my head.
Serious?
You're not allowed to touch an officer.
No, I would make conversation with you. Before I
With my face like that?
showed you what that girl did to me. And
What you say, hey officer, can I show you what you did to me?
she still got me.
You were all like, da.
Go ahead, put it in.
I got into a fight in high school. And the girl beat me up because I won't get arrested. So I wish he would show me a video of me touching that lady back.
It'll all be evidence. That'll all be evidence.
It's fine.
Because we were both standing there with our cameras.
Yeah.
And you went like
You
this
asked
to
me
her.
what happened, and I said, this is what happened. And I showed you how she got me with my head. And you threw me on the
No,
ground.
this is the second time we had to deal with you. When you tried to come back. You were like, yeah, you were like, what's your name, blah, blah, blah. You hit me in the top of the head. Remember that? You were recording. You were on
Tomorrow
phone.
you gonna see us in court. I wish it was your touch. I would never touch it.
Let's put her in the van.
Ariel!
We're done. Goodbye.
Tell the Ray, take you to
So
jail.
crazy.
You get to see the judge in the morning.
Oh, y'all pussy as fuck. I don't know.
Okay. Are we waiting for motor medics? Huh? Are we waiting for the medics? Yeah. All right, just hang out here so they can look at her. Let her out. They're right here. You're just gonna have a seat right there at the edge.
Just sit there.
I wouldn't mind going through the fucking
She just has a scrape on her shoulder. She's bleeding from her.
Oh, okay.
Just
Oh, okay.
because they're gonna.
Let me go grab your bag.
Okay.
Hey, LT.
Hey, buddy.
This case illustrates a critical legal boundary many citizens misunderstand. Any intentional touching of a law enforcement officer without permission is criminal battery, regardless of intent or purpose. Florida Statute, Section 4.07, elevates simple battery from a misdemeanor to a third-degree felony when committed against law enforcement officers engaged in lawful duties. The state must prove 4 elements. First, the defendant intentionally touched or struck the officer. Second, the touching was against the officer's will. Third, the defendant knew the victim was a law enforcement officer. Fourth, the officer was performing lawful duties. Critically, intent to harm is not required. Intent to touch is sufficient. This means gentle contact, demonstrative gestures, or touching to get attention all constitute felony battery if done without permission. The statute carries up to 5 years in prison, 5 years probation, and a $5,000 fine. Under Florida's Criminal Punishment Code, this ranks as a Level 4 offense, making prison time a realistic possibility even for first offenders. The law enforcement officers receive a grade of B. The arrest for battery on a law enforcement officer was legally justified under Florida Statute 784.07. When a subject makes physical contact with an officer during an investigation, arrest is appropriate and within officer discretion. The officer's statement she had every chance to walk away suggests attempted de-escalation before the battery occurred, demonstrating restraint. Use of force during the arrest remained proportional, limited to empty hand control and handcuffs, without strikes or intermediate weapons. Under Graham v. Connor's objective reasonableness standard, this level of force was justified given the subject's resistance. Officers properly requested medical attention when injury was observed, fulfilling their constitutional obligation to provide care. They maintained composure despite verbal hostility and continued resistance. However, communication deficiencies prevent a higher grade. The subject's repeated statements of confusion suggest officers did not clearly explain that arrest was for touching the officer, not the original altercation. Better communication often reduces resistance and prevents escalation. While officers performed legally, clearer explanation of the specific conduct that led to arrest would have demonstrated superior professionalism. The subject receives a grade of D+. She committed a third-degree felony by making intentional physical contact with a law enforcement officer. Under Florida Statute 784.07, the moment she touched or gestured toward the officer's head, she satisfied all elements of battery on a law enforcement officer. Her apparent intent to demonstrate where she was struck is legally irrelevant. Intent to harm is not required. Only intent to touch is necessary. This single action transformed her from a potential witness or victim into a criminal defendant facing up to 5 years in prison. Her resistance during handcuffing, evidenced by commands to stop moving, added a first-degree misdemeanor charge. Under Florida Statute 843.02 for resisting without violence. Her verbal denial of touching the officer, if contradicted by video evidence, creates credibility problems at trial. This case demonstrates a fundamental misunderstanding many citizens share. People believe they can touch officers to make points, demonstrate events, or get attention. This belief is legally wrong and criminally dangerous. Any intentional touching without permission constitutes felony battery. However, several factors prevent a failing grade. The subject's confusion appears genuine rather than feigned. She seems to believe she was arrested for the original fight, not for touching the officer. This confusion suggests ignorance rather than malicious intent. Her emotional state appears elevated, possibly impairing judgment. The presence of a service dog suggests a possible disability that may affect perception or response. Her statement, "I'm so sorry," indicates some recognition of wrongdoing and remorse. Most significantly, the contact appears demonstrative rather than violent. While this does not change the legal analysis, it affects moral culpability. The D+ reflects serious criminal conduct balanced against apparent lack of violent intent and genuine confusion. 5 critical lessons emerge from this case. First, never touch law enforcement officers during any interaction, regardless of your intent or purpose. Demonstrative touching, gentle contact, or gestures toward an officer all constitute felony battery. Under Florida Statute 784.07. Second, intent to harm is not required for battery charges. Intent to touch is legally sufficient. This distinction is crucial and widely misunderstood. Third, keep your hands to yourself and explain everything verbally. You can describe, explain, and demonstrate using words alone. Physical contact is never necessary and always criminal. Fourth, if you believe officers used excessive force or acted improperly, the time to address this is through legal channels after the encounter, not through physical contact during the encounter. Fifth, service animal rights, disability status, emotional distress, or confusion provide no immunity from criminal law. These may be mitigating factors in sentencing but do not constitute legal defenses to battery charges.
Confused on what, like where you are or what's going on, or?
No, that police officer, I knew what was going on when they said they were upset on my dog being a service dog, because I was confused on why the dog had a problem with my dog. And all of a sudden the cop was like, what happened? I was like, this lady all of a sudden grabbed me by my head. They showed me how she got me, and all of a sudden I was on the ground. So I'm very much confused. If any of y'all witnessed something else, like, please tell me you witnessed something else.
We've told you several times when we witnessed.
Yes, no, when the lady said we're getting the police, and the guy came, I told him, let me explain to you what happened, because I'm very confused. I have a service dog for my wife and everything. My dog's not a biter. My dog isn't licking. My dog's just walking. And you don't think my dog's going to come in a lie. And then a lady who had nothing to do with the store, they told me, please understand, that the lady who had nothing to do with the store is the one that started fighting me, right? Like on some Daytona stuff. I don't even work out here. We don't deal with this stuff in my club. Like at all.
Hi. You got the shoulder and the wrist, LT. Okay.
Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.